2025. Welcome to the audience. Welcome to our listeners. This is Mohammed Shilon coming to you from the USA. And with me, my co-host, Mr. Victor Mengot, coming to you from Surrey, England. Broadcasting or presentation for make them call in, because this is being done in real time. You go. This is VOS television, by the way, VOS television broadcasting platforms, where they can bring this presentation through. If you go on YouTube, bring this presentation through. If you go on YouTube, you go on VOS television, you will be able to get we. If you go on Facebook, VOS, www.vosradio.com, www.vosradio.com. Now, also, you can get we on this same radio station, but for be able to get that, you venues, medium, then we carry we live as we are making our presentation. We also get what you will call the VOS Diaspora Helping Hands non-profit organization, where we always ask people for make some control, press forward the completion or the continuation in high school. So they want, so that this diaspora scholarship program is all about. So we always encourage people for please present, give, donate, whatever you can, as much as you can. No explanation as to the criteria in selecting people for this scholarship program. Okay, so that said, we get certain issues then today, one for discuss, as we always deal with trending issues, and then we want to make some critical analysis of what is trending, constitutional gear. So we'll discuss some of the facts, we'll go into the narrative, and then we'll go try for touch on the constitutional issues and the delegation of power, and some of these powers, which ones are appropriate, which ones seem to be in violation of the existing constitution, and laws are passed by Parliament and they don't seem to have been properly done, either procedurally or in contravention of the constitution. There are a lot of folks who should take issue with it. The legal professions, the law society, the bar society, that depending on how things flow. I'm going to ask my co-host, Mr. Victor Mengot, who comes to you people, not as a stranger, but as someone we all are familiar with, and who every day he comes on, leads.
And of what we've been on to talk about. The Kush debate is still continuing. Not just Kush, because Kush is just one affliction. Drugs here, especially Kush, where they don't arrest, where they don't take before the law. But there's more to be done. But today on, the first partner for look at Parliament, waiting at the role of Parliament, because they debate them. Now we expect with Attorney General, we don't have law them. It's over 40. When one can go Parliament, let Parliament go ratify. But then law and they, up till now, not in the Republic. And then law and they will therefore affect with government. Spokesperson or an independent referee. So now listen to this, to go analyze this video in a free for kind side. A lot to
monitor high seas, to monitor the ocean or water is so expensive all over the world. It goes into hundreds of millions of dollars. It's very expensive. So government is really struggling to monitor the waters of Sierra Leone.
Okay, never mind. I will talk
Right.
over it.
Okay, let's.
Okay?
Mr. Mengo,
We
do you want
live
to go
now?
ahead? Huh?
Yeah. Yes.
Now I say, do you want to go ahead and let's
Yes.
for the government for doing job? They say we lack so many resources. It's a big job. So by implication, the speaker is implying that we should just give up, just do the best we can. So it will lower the bar of without the United Nations, we cannot think for ourselves and come up with ideas and ways and means to protect ourselves. We are at the mercy of poachers, of encroachers. So who got their information, their education abroad, a good many of whom went to renowned universities like Frabe College, Jala University, and now we just come up with this position of helplessness. We're too poor. And I take issue with this abundance. That's a country of 7, 8 million, let's say 10 million people, even though we're not that much. But look at it in the light most favorable to the speaker or the government. It is very disheartening that we get for your thing to come up from the mouth of the speakers. Then it's not for us to come up with determination. Nobody asks these guys to come into government. If they can't do the work, they don't need to volunteer. But we know which brings a lot of them into politics, not for the interest or in the interest of country. Now, self-interest to bring most of them into politics. So the nurses away, thereby undercutting our ability to effectively and ably protect our boundaries. It seems to me that's what we're doing. We shoot ourselves in the foot, and then we claim the inability to move. So these are some prior to the Aneskuruma government, we had a parliamentary system of speakership whereby the speaker was an independent person, again, no party affiliation, was not a member of parliament. I never subscribed to the idea that you get to take a retired judge or a judge or somebody from the legal profession. The speakership doesn't call for that. It doesn't require any particular training. So when the APC government, the Aneskuruma government decides, say, then change is not lead to progress. It wipe out about how we talked a few minutes ago. The speaker sounds like a government spokesperson. The speaker sounds like a government spokesperson, not like a speaker. Now, understand, say, to me understanding, that's why we have Mr. Mengo here. He's an elected parliament, should get rid of the old government, the SLPP should get rid of the old garment, the SLPP garment, and put on a garment of neutrality. That's what a speaker should do. It's no different from when you are a lawyer. Let's say you are a prosecutor, temptation day, and conducting yourself in the capacity as a referee. So this doesn't tell well of the speaker, wherein they become the government spokesperson of the speaker, wherein they become the government spokesperson. Because what good is the Minister of Finance? What good is the other people who are in the
These people then get for look at texts in which speaker in your view. When I say speaker in your view, when I say government take responsibility, the thing the way the government may for do. The speaker, the thing the way the government may for do. The speaker they talk like say sharing within the executive in line with the PR system. The debate issue in a salon is still a one. as we say, the speaker is also entitled to a national emergency because it's a disaster. A national emergency because it's a disaster. I don't think say beaucoup people we are aware say on the 9th of April last, the president make decision, waiting at the proclamation where the president be make decision, waiting at the proclamation where the president be make, and why be make them, and since that instrument need to expire, waiting. So we get some extra measures them where the president can do. But normally, when you get a state of emergency, if it's not a constitutional instrument, it is just a proclamation. Should we review what they mean the act for first before this one? So for that put let people know, I go say waiting the proclamation be say emergency. And why we've been getting state of emergency? Then talk about drug and substance abuse, particularly this push when a public health emergency, the national concern. Don't get regard to these threats, and it declares this proclamation that the state of emergency will exist for the whole of the country with effect from the 4th day of April 2024 for a period of 12 months. The state of emergency. And the judiciary for be able to review them. Then also restrictions of movement. So, but it look like nobody now be understand, say, even this state of emergency day. And what benefit you get up till now. Because it's either they come through the airport, through the seaport, by sea, or through the borders. So, is there a need for another state of public emergency?
Craftsmanship. One of the fundamental things for make sure or hurdle you get over. Now for draw it with such clarity, we are talking about, just 1 second. We are talking about the construction of this law, emergency law. 29, they say, this portion allows for temporary derogation from certain fundamental rights, which means the derogation, when they talk about suspension, it means the suspension. Let me ask yourself, how can we justify a state of emergency, or can we justify a state of emergency if there's a widespread creates such threats to the security of Sierra Leone that a state of emergency is required? Who is threatened except the user of the drug? Now, how do we connect this insecurity of Sierra Leone? 3 months, the original 3 months, giving of power, then 1 year, then not going back to parliament with the government for do. And so we have no contribution. You see, when you use Kush, now you said go take up. But if a hurricane blow, now I just want to know if we are really complying with it as the Constitution requires. Again, let me go to Mr. Mangot for further disclosure. Executive order, which shall be published in the Gazette, declare that a situation exists which, if allowed to continue, may lead to a state of emergency. Again, what is a state of emergency? May lead to a state of emergency doesn't describe to us what emergency means in this sense. May lead to a state of emergency in any part or whole of Sierra Leone. whereas the drug and okay, I can't figure this word out. And abuse
Okay,
substance.
I can read it for you. It says, whereas the drug and substance abuse, particular for devastating synthetic drug kush, is a public health emergency of national concern. Public health emergency of national concern. And Lord put her in context, the only time where we don't get public health emergency in a salon of recent, now during the Ebola, and secondly,
COVID.
During the COVID. But I go to the Constitution for you. We make sure, say, when Parliament, they pass their lawyer, they get for look at the law. 2, acquisition on behalf of the government of any property other than land. C, authorize the entering and search of any premises. And D, amend any law, suspend the operation of any law, and apply any law with or without modification. So you see, when you declare that state of emergency day, where the president will make proclamation, these are some of the powers which the president may execute. We're not saying in this case he execute that power, though. What do we want Parliament for do now?
Based upon the requirement of the Constitution, there is no basis for a declaration of a state of emergency because there is no clear or present danger to the safety of the public or of the country. No one is endangered other than the one that would use them, the one that would sell them. They are just violators of the law selling illegal substance. And statistically, we're not getting empirical evidence that out of 8 million people in the population, any number of percentage of people, they buy, sell, or use kush. So if we get an 8 million population, let's say in the Freetown area, 5,000, 10,000 people are using kush. Of course, that's a high number. Black people, kush victims, these people are victims more so. They are helpless. But they pose no danger to the rest of us who walk around them. We stand there, we look at them, we laugh at them, you know. So how is there a clear and present danger to the security? So we're misusing the purpose of the law. A state of emergency has not arisen to justify laws for ratification, laws that nobody knows, nobody has seen. They don't even ask anybody. They just decide to go, and if they take 40 laws, the parliament will pass all because the parliamentarians are not serious either. They not analyze anything. The opposition party not analyze anything. So then an executive order or a state of emergency, they need to go back and read the Constitution and interpret it well and see if the purpose for a state of emergency to be declared has been met, which I argue has not been met. So,
and since that was done, what difference made to the kush situation? If it hasn't made any difference, then 1, there was no need for it. 2, Parliament has reneged on its duty to go back after the expiration of that 12 months to examine the situation and see what can be done and bring the different agencies on board for them to can give an account of their stewardship. The Ministry of Health and Sanitation, the National Drug Law Enforcement Agency, we don't get inside, we don't go before Parliament, we know. The Office of National Security, all the other people, the way they do advocacy. That is what is needed now. So Parliament passed a law, when a constitutional statutory instrument for 12 months, which, according to what you explained so now, was not necessary. So what next now? The judiciary. And if you look at the law, when such law is passed, the judiciary should also come in and monitor the situation. We've never had anything out of them. Only recently, the Chief Justice just appoint 5 judges and I think 2 magistrates for deal with drug cases. That was not done during the period when we had the state of emergency. So are we still doing some firefighting on this whole issue? Then we talk about protection of our borders. How can we cooperate with our neighbors in this fight? So that is my take on this. Unless you get other thing, we want to go to this second part because it already mentioned, and then laws there with the attack say Inge for care before Parliament. And the ECSL commissioner, the acting commissioner, will go and look into him. Look at him video where he tell we waiting and waiting and not do. And then we'll go do an analysis and look at some of the laws them we will affect the next election when nothing is being told us about that. So over to the control room for play this video for me.
They say we don't do not yet about the policies. Look at policy on recruitment and management of ad hoc staff. Look at the other one. Stakeholders engagement policy. We don't do that. Look at public information and document policy. We don't do that.
All right. So now you get anything where you want.
Yes, I just want for make clarification on some of the radio discussions them with particular political parties that they talk about. Say all of these discussions where they get to now, or even some of the colleagues the way they update political parties, we have not done anything. I want to dispel that categorically that we are on course. And I don't want many people they know say not for tripartite no more we don't have a commission. We have a lot of other systems and processes in place. As we are seated here, a lot of them discussions they will relate to the tripartite. They're already inside with strategic plan. By the end of the year, we will get for complete with strategic plan. People then will see all of that in them. As I see here, they say we don't do not yet about the policies. Look at policy on recruitment and management of ad hoc staff. Look the other one. Stakeholders engagement policy. We don't do that. Look at public information and document policy. We don't do that. The next thing we get for do no more now, as a commission, we don't already approve this in our working document. But for many people that own this one, for seeing that the owner, when they go around for validate to strategic plan, when they present them back to them. So they approve them. Because we go get discussions with them around that. Then again, on legal reforms, as recent as 1 or 2 weeks ago, look at proposed amendments to the Public Elections Act of 2022. So we are doing all of this. And we are informing political parties. We are informing our stakeholders. We are working alongside with the Office of the AG and Ministry of Justice. So that tells you that we are moving. This train is not static. The train of ECSL is moving. That's the assurance I want to give the public.
Mr. Mengo,
Before you
me.
answer, Mr. Chairman,
Okay.
let's look at the second part where it says legal use and propose amendment to the Public Elections Act. They don't do all the amendment there.
So what are they?
So
what are the amendments? What are the proposed amendments?
that is the question.
I think that's the
And
question. He's showing us headlines and sub-headlines with no substance on the page until we watching and don't do. It doesn't show, look at this. But watching at the proposed amendment, the way they talk about what they don't do. What are they?
And
I found that to be ridiculous.
and a strategic plan where
Yeah.
at the end of the year, the strategic plan. But for this discussion, we get certain recommendations we want to look at. We're very vital to the next election. We don't choose 4 and let fumble them. They look at them. Let's start with in the present man who the CISO, Mr. Edmund Alpha. He is the commissioner for
Acting.
he is commissioner for the South region.
Okay.
So we know say the substantive electoral commissioner, when Mr. Mohamed Kane, we don't give notice in which for continue in that position anymore. So the president appoints this gentleman in an acting capacity for do the review. But his appointment again, it take the status quo. Now go to the first recommendation. Now reports where, if we go by that, his position, even in carrying out this one, is not clear. Because it look like nothing on change. And I will go to the end day. If we look I go read them for Fambulem. Not only him, but the other commissioners them, when recommendation 38 of the tripartite report. 36, sorry. Let's read them. The recommendation say now for amend section 32(3) of the Constitution and section 2 of the Public Election Act and section 34 of the Constitution for provide the people away for day now that such party day now the Interreligious Council, the Bar Association, the Civil Society, the Labour Congress, the Sierra Leone Association of Journalists, Women's Organization, Youth Organization. And for putting in the public, now look at the section then at the Constitution for amend. Because then they talk about section 32(3) of the Constitution. We fumble them. Let them know what's in a section 32(3) so we can debate that. The members of the Electoral Commission shall be appointed by the President after consultation with all registered parties and subject to the approval of it. A person should be qualified for appointment as a member of the Electoral Commission if he is not qualified to be elected as a member of Parliament to hold office as a member of Electoral Commission. Now that decision do amend. So, waiting at the qualification now where they look for. Then say for let you be somebody from the Electoral Commission, you get forget certain qualification. And that qualification they what you refer to. You say the person get forget experience in he get forget particular qualification and then get for shortlist them and make 3 recommendations, 3 persons to the president for appointment. Recommendation 35 say the Public Election Act to require professional qualification and experience in governance and public management for an electoral commissioner in addition to the other recommendations. So that is the issue. So if actually they want us to continue, by now, the government for don't put this search party together, then for don't allow all them commissioners for stand down and appoint new commissioners them, where go this process too. But then they argue again, the obverse is that the law na Parliament, so if the law na Parliament not change it, we still they go with the status quo. That is a big quandary. What I mean? Now a situation where until the law is changed, we will still do waiting in the question in terms of appointment of the commissioner when they go get for conduct the next election. Over to you, sir, before we go to the next point.
Yeah, if you don't mind, I'll be just one touch before I get back to this. You mentioned something about the Kush business and that the Chief Justice do appoint about 5 judges for deal with drug matters. I find it kind of strange how the judiciary, because to me it looks like the judiciary, they inject themselves into legislative and executive matters. Because the judiciary they not get no social role for playing here, other than when matters are brought to them, for be the arbiter or they get for be matters of legal issues. Now, if the Chief Justice they appoint 5 judges, how does that make the system any more efficient? How does that solve the Kush problem by appointing 5 judges? Or sometimes it makes no sense, because these people who are using Kush, based upon what we know, if you talk about the for arrest and charge and prosecute those people, the traffickers are not so many that we need that many appointment of judges. So I don't think we get to the real issue and the solution.
Now, just to make it's not appointment, they assign 5 judges.
Whatever word is used. Whatever word is used.
For take care of those cases that are drug related.
Okay, here's my question.
Existing judges who have been assigned to perform and speed then trials, then we will come before them for drug related offense.
Well, here's the question. Because we have to go with the facts. The traffickers are not being arrested. Who are they? Who are they? Who? For whom do they need all these many judges? For the victims who are never in the right state of mind to be tried? So what are we talking about? Who has ever seen a Kush user, a Kush victim, sober enough for go to trial?
Now, I think the judges, the people they are targeting, put it this way, the people who they have arrested so far are people who are retailing them, people who are suppliers, people where they sell.
Are they that? Are they that many for 5 courts or 5 judges? You see, we're not to deal with numbers because we exaggerate. Because let's say if there are 50 such arrestees, that doesn't justify 5 judges. 1 court can do that. 2 courts can do that. You see, everything is being exaggerated. We're not to deal with solution. We're not to deal with efficiency. They don't need 5 judges. There is no statistical evidence that we have so many cases of sellers and traffickers. We do have a lot more cases of users who are. So why have 5? Plus, you have to have prosecutors, court personnel. Does that solve the problem? It's not going to solve anything. 1 court can dispose. Let's say we have 200 arrestees who are sellers, who are traffickers of Kush. 1 or 2 courts can deal with that. It's only a matter of administrative efficiency. So when they make all this headline about they don't appoint 5 judges and that, listen, some of us have been in the system. We know that's just talk because these people don't know what they're talking about. You see? And the poor victims, the users, who don't even have the soundness of mind are the ones being arrested, locked up. I can look at it and tell that will not work. They can appoint 100 judges on cush matters. That's not the solution to the problem. You know, now the effective, efficient administration of justice now will solve the problem, and the courts have very little role. They have very little role here because unless the cases are brought in front of them, they can't do anything anyway. They can't go out there looking for victims or sellers. But that's all. I was just going to touch on that. For me, I'm not impressed when I read about, 5 judges have been appointed, 20 judges have been appointed. You know, without a real engineering, so they were talking about people in the language not jail for years for simple jail now. No.
Mr. Shilon, to put it in people right? Yeah. Now look at the announcement from which you get the research. It says Sierra Leone's Chief Justice, Honorable Justice Combat Commander, has appointed 7 judges and 3 magistrates to specifically handle drug cases and other matters ensuring continuous court sittings, including on Saturdays. The move aims to tackle drug-related crimes and enhance access to justice, particularly for detainees. Waiting at the key highlights, especially magistrates appointed for drug trials, weekend court sitting. Courts will sit on Saturdays to decode the Sierra Leone judicial system. So that is what they are saying.
All right.
Mr. Shiro.
Yes,
so that is the official what they've said.
Okay.
From this, which I read, so it's as if the implication is that there are so many people in detention who are waiting trials for drug-related matters. What we don't know, whether there are people who have been arrested for illegally taking drugs, or whether they are suppliers, or whether they are traffickers. That is the thing that is unknown. As he said, we don't get because in this, on the 20th of October 2022, this notice will come up from the judiciary of Sierra Leone. So if we can put them further, we control room the SWAM. So this 9 are the notice. So I think you don't see an
and you are caught based upon what you see on videos, would see a large number of people who are under the influence of kush, all kind of a social input in terms of psychologists, psychiatrists, hospitalization. So it's a more complex problem. If it's for the users who it seems to me are in the vast majority, I am not convinced that we have that many drug sellers or traffickers in jail or in detention or awaiting trial that will warrant 7 judges and magistrates. Is all I'm saying. I'm not convinced that we have that many sellers, traffickers, call for trials or imprisonment, a call for treatment. That's all I'm saying. So we can make it to call on drug-related offenses, but I think we have one solve the problem, let's deal with the issues and not to just make this big show. That's all I'm saying. You can get 200 judges. But I'm not convinced Sierra Leone has that many drug cases that they need all that. Well, they need staff for even support all them judges here, and they are a lot of stuff. So, but I don't want to be late spoken about the other issues. Then we'll talk about. I will just digress to this point, but you had moved forward. Let's deal with that.
No, but the ones I've moved forward to is actually again looking at the tripartite report and recommendation. We are assuming that some of these 40 laws they were unchanged, that laws them were based on the recommendation where we don't know. So let's go to another one where I feel to say we can discuss. We're very important. That is the one for dealing with recommendation 38. And then very important, very critical, and I will read them. Recommendation 38 say the Constitution to be amended so that the proviso to Section 38(4) to be amended so that only data from decimal census to be used for electoral purposes. La talking a Creole. What did they say? We go only use census figure, that 10-year census figure, then data for let we get decide on constituency boundaries. It go to Section B, recommendation 38, paragraph B say, therefore, puts that the Constitution, it should be inserted at 38.5, that where the final report of a decimal census is published at or less than 24 hours before a general election, the data collected from that census should not be used for the purposes of delimiting boundaries. So let's tell people them, family them, waiting Section 38.5 being at the Constitution. Because in the Constitution, Section 38 say Sierra Leone, World Campaign 1, Sierra Leone shall be divided into such constituencies for the purpose of electing members of parliament. So, if you look at Section 38.5, where they say for inside, so where the boundaries of any constituencies are altered in accordance with the provision of this section, that alteration shall come into effect upon the next dissolution of parliament after the alteration has been approved. So in other words, the recommendation where they make now, what it clearly say, even the census data would expect get the census in December 2025. Then data they not go make, we not go use them for create constituency boundaries and constituencies. And even if we get them, it get for be published not less than 24 months before the general election. What does that mean? It only means say we will go back to the status quo where we not go get constituency for the next election, and then they go warrant the PR. I want to let you go much on this thing why I don't say so.
Well, that I can going with the current trend of preparation for the upcoming election in 2028. It appears as if they are not going to be able to meet the requirements for even put into effect, because it will be less than 24 months, much closer to the election before all them requirements are met. That's what it looks like, because the whole process is still ongoing. It should have been started a long time ago. So again, you are the expert on that. Correct me if I'm wrong. That requirement, this Section 38 situation is concerned. A look over say 38A is going to be the prevailing system they're going to go along with, and it may, even though government realized that there are conflicting requirements under Section 38, one at the PR system, but the look for say they get the preference for the PR system, so they did very little in terms of clarifying and passing superseding laws. Then we'll go just make sure say we'll get it clearly defined going towards the 2028 election. So it seems to me, again, Mr. Mengot, if I'm correct, that they have not embarked on the necessary preparation, and it appears in America, I would say, and the parliament or the government has been slow walking this Section 38 issue for make sure say we not meet the threshold. So
the point is, here is the situation. Let's look at the existing law for it, right? And that existing law, now in them in court in 2023, Section 38, subsection 2, it said the boundaries of each constituency shall be such that the number of inhabitants thereof is nearly equal to the population quota as is reasonable. But if you check at Section 38, subsection 2, it says every constituency established under this section shall return one member of parliament. So now 38, subparagraph 2, within the Constitution. So if you go by waiting these people and they say, the insertion, now for look at waiting will happen after, but it not tell we say it don't cancel that section we say if we not get constituency boundaries. They can decide for use the PR, even if we go into all this consultation. And these are some of the laws which are critical for the next election. And that is on that.
So it's reasonable to assume, again, correct me, like we say, reasonable minds can differ. It's reasonable to assume that Section 38A is going to continue to prevail. So
definitely so, because
2028. Yeah, go ahead.
That's definite, because it has not been expunged from the books of the law. Months before an election, the data collected from that census should not be used for purposes of delimiting the boundaries for use at the general election. So what that simply means is that even you do the census this year, as was scheduled, December 2025, right? By the time they're done, they go 2026. The same figure, you cannot use it for boundary delimitation for election for 2028. Because by the time they're done, it will be less than 24 months. That is the technical side of it.
If it is applied if it is not applied to the 2028 election, applied to a future election, will that be in the spirit of the tripartite recommendation?
No, it wouldn't, because the whole idea is we are consulting on PR system for first past the post, right? And even if we opt for, let's say, we follow the public recommendation, majority recommendation, that we should go for first past the post. We cannot get first past the post if we don't get constituency boundaries. That's the anomaly. So this whole exercise, in my view, is an exercise that gets paid from the consolidated revenue. So it extends to ministers because they are paid from the consolidated revenue. It extends to civil servants. It extends to head of parastatals and technocrats. Then they say for amend section 76(1)(b) of the Constitution. So let's go by 76(1)(b)(9) deal with who stem people for resign from their position before they go eligible for stand an election. Either X1, no person shall be qualified for election as a member of parliament. Under subsection B, if officer or employee within 12 months prior to the date on which it seeks to be.
A year to 6 months. Did they give a reason?
Well, they must have deliberated it.
Which they always
if
do.
You remember, okay,
I
if you
which
remember,
they always do.
okay, some of the election petition where they make, some people, you remember when this, where they pull some member of parliament, of the fulfill that criteria for resign and job in time within 12 months. So if they receive salary from the consolidated revenue, let's put it this way. In other words, let's say the election now June 2028. So under the old constitution, it means say by June 2027, you don't resign. Now make the deadline for your resignation for be December 2027. That is what they're saying. And then one of the laws them where they get for go change in the parliament. Where we don't know it's waiting and not say.
Well, it seems to me it will not matter. I still think, say, 6 months is a reasonable time for resign your position if you are run for office or do any other thing. And so I don't think it's unreasonable. Of course, 12 months is preferable, but if you're changing for 6 months for whatever reason, I not get any argument against it or for it, you know. So that I mean take on it. I think it really doesn't matter.
But I mean, that's true. I am of the same view as well. But if these laws are supposed to be taken to Parliament, we don't know whether this one is included in the 40. We don't know when they were going to be in Parliament, when they're going to be debated. So these are some of the unknowns. We just bring them out as example or some of the things that you get people away. I mean, for instance, I'll give an example now. You have people who are members of the cabinet now, right? Who might want to be presidential flag bearers. The same people who are appointed for public cooperation to an act of we want to be presidential flag bearers. So if that flag bearer election they take place before 6 months before the election, it means they cannot contest. That is the way I interpret it.
And to me, it seems like if there is any flaws in that requirement day or any unreasonableness in that requirement day, I think the opposition should be on the forefront opposing it. But if they don't find it inconvenient, because I think it affects both government supporters of both parties, even people who are in government working in other offices, I think it affects them just as equally as people who are not in place. So it looks like the law, this 6-month requirement might even have a more effect on those holding government offices than even people on the other side. So I don't know whether that was the intention behind the law, but I think that would be the effect of the law if they approve the 6 months proposition wouldn't come up with or proposal. That's my position. I think it will affect the government or the executive members more than.
This was one recommendation. How come it's only these two who are the ones that are involved? The others, then they consult them. But anyway, let not belabor the point. Like to the last one who I choose today, we then I feel to say it's supposed to be an entrenched clause in the Constitution, and I feel to say it will require a referendum. And it's very interesting. Now something where they always they argue about. And I will read them for you now. Then at the last one we'll get for tonight, we say for allow independent candidates to nominate for presidential election through amendment of Section 41B and Section 42(1) of the Constitution. Additional conditions for independent candidates may be considered by Parliament. In making the amendments to the primary legislation to allow independent candidacy, there should be full application of all regulatory requirements relating to the conduct and financing to be applied to independent candidates by electoral commissions and the political party regulation. So what this is saying now? It's saying now, then they recommend say, before, one of the conditions, let me me go to the relevant section of the Constitution where they were amended. They talk about Section 41B and Section 42(1). So let's go to Section 41B. What do you say? Then we'll come to them. Because this is a critical change in our Constitution and it's critical for the next election. 41B. Section 41, it talks about qualification of, it says no person shall be is a citizen of Sierra Leone, but being important, is a member of the political party. So now that one almost I will spend for me election. So
it's a good take on the idea that one should not or must not have to be a member of a political party to be president. Because I see no, what you could do, someone who simply holds a Sierra Leonean passport by virtue of the person's financial ability to make an investment, or Mr. Musk or Mr. Bezos, these guys have hundreds of billions of dollars and a net worth. What if any one of them decides, say, you know what, I got enough money, all I have to do, just decide to invest anywhere from 10 to $100 billion Australian, and then overwhelm the opposition or the other members there with my wealth, buy everybody out of the country, and become elected. I was not born in Sierra Leone. I only become a Sierra Leonean because I was able to obtain a passport. Are our leaders anticipating or are they foreseeing such an occurrence? Because we need to learn, because America is going through the, well, it looks like we are undermining our constitution because the conditions they were putting out for one to become the qualifications them, and then they get, because we don't get to the point now where we need to define who is a Sierra Leonean, what constitutes Sierra Leonean citizenship, because of the recent activities of giving Sierra Leonean citizenship with Sierra Leonean passport. And like I say, it is a internationally recognized definition that possession of a country's passport is proof of citizenship. So let me just think about that. So I don't think the way they got now in this proposal, this what they come up with, I don't think they really get full appreciation for the danger that lies ahead. But I don't think it's a wise move. They need for redefined citizenship with all them proposals here. We didn't see any kind of proposal, but I haven't seen anything yet. I agree. I think it's reasonable for one not to belong to any party and still be able to run for the presidency. I agree with that wholeheartedly. But you gave me a recommendation a lot of times. Whenever any legislation is passed by Parliament that seems to be unreasonable or contravenes the Constitution, go to court. The lawyers, the opposition, then should take these matters to court. That's what the courts are for, to interpret the law, and apply it. That's all I can say. I don't know if what I'm saying makes sense, but this is my take on the whole thing.
Well, you're right, but today is very interesting. We bring out NTR for say, number one, the 40 laws the way the Attorney General don't draft, we never see it. And some of them will bring up today, now things that we get for affect with elections management system and Udaga for stand election. So we they make appeal to the government or the judiciary or to the Attorney General. If you can share the boku the lawyer we do amend. Just like how they share the tripartite. It's not enough for let get the commissioner. the acting commissioner, not even a substantive commissioner, they tell we all the review where they don't do. But then I think say people this today on broadcast is very unique because then at the first send this where we don't spend almost 2 hours without a single phone call. We don't know if people they understand, but before we go, we'll ask the control room if there's any probably comment on the section, whether on Facebook or YouTube, we can just respond to, because I think so we don't do a lot of justice to this constitution and parliamentary proposal. If we don't get nothing, I think say this will be my last word. That is very, very interesting. So over to you, sir. For the first time, we don't make we don't set a record. We'll go almost 2 hours with debates. We have not been challenged either positively or negatively, and we do hope our listeners they're able to take a lot of sense from what they say. So with that, I think saying my last word is. So over to you, sir, to give you last word and until we meet next week.
Yeah. All I can say to listeners then, sometimes we may sound boring, if at all that has anything to do with calls not coming in. But we don't think not to criticize government. We don't think that for enlightening with people them. Because then think they when then come, then begin affect people and then begin complain. And I think say we were there in the information giving business. Now we job for bring out things that what people might not know of, and if they know of and they don't understand. So it's not surprising that sometimes it's not as appetizing as say if we were to deal with an issue like Judge Stevens and his girlfriend. That may bring more things, but there is some degree of substance to then kind of an information day, all depending on how one looks at it or analyze it. But that doesn't, then sensational thing, then they then get their own place. But these are things will go affect people them down the line. So if we not pay attention, when we supposedly educated people, when I not raise issue now, when I not take the opposition them to task, all the opposition political parties, and then when things happen, when I can't keep just blaming the other side, when I get opportunity for contribute and make suggestions. So we will try important and relevant, but we rather advise it for both the opposition, parliamentarians, educated people, because we get issues like, oh, they talk about the Attorney General get 40 laws where they just want to go even a parliament, and all those 40 laws will become law, proposed laws. Actually, they are not laws yet. Now, 40 proposed laws, them. Ideas that we want to become laws. They have been held in secrecy. Nobody knows anything, so we can share we own 1 or 2 cents, but they not do that. So the lily what we don't get now we don't share with you now. Now we not for sound the alarm say that process there is not fair, it's not right, it's not transparent, and so on. So until then, we greatly appreciate all those who listen. So we hope we hear it from you again next Sunday. Until then, good night.